Welcome to Kanooni Charcha. Today I am going to discuss in this episode the cruelty to women from husband's side or by his relatives, husband's relatives. Now, you might be knowing earlier there was a section 498A Indian Penal Code. That is now new sections under BNS Bharatiya Nyaya Sahita. You will find earlier there is one section 498A, this Indian Penal Code. Now it is divided into two. In 85 you will find the definition. What do you mean by cruelty? Cruelty from husband side or from his relative side to women. This is a definition with regard, and explanation is given on in another. There is a two section now, 85 and 86 of this of BNSS replaced. Earlier there was a section. I am again repeating this section 498A of Indian Penal Code. Now I will come to this. This provision has been misused. This is a general conception among these law courts, even constitutional courts, and many times, in many cases, many times the false allegations were leveled. The allegation may be true against husband in some cases, but there is impediment of the relatives. Relative is a very vast. Married sister-in-laws are involved, who are sitting abroad and who have been married somewhere in distant other part of this other country. They are also have been arraigned as accused in this criminal proceeding. FIR is lost and there are charge sheet. One has to face the criminal trial. Now, then you will find a judgment, very important judgment. Earlier, the Supreme Court of Supreme Court of India, Preeti Gupta versus State of Jharkhand. A direction was made to legislature, to the Parliament, Government of India, to this see the misuse of this section and do something on legislative side to amend it, to modify it. Then this case, I will this very much, but legislature has not done anything in compliance to the direction of the Supreme Court. In now, I will first directly go to. Then I will touch with this. In new judgment, you will find Achin Gupta versus State of this Haryana, State of Haryana. Now I will directly go to first. But for the facts of this Achin Gupta, then Preeti Gupta has been discussed. His assistance is taken in order to decide the Achin Gupta's this criminal appeal, you may say. In Achin Gupta case, it is a 3rd of May 2024 judgment of Supreme Court of India. This FIR was lost by the wife against her husband, making many allegations of this, you may say, cruelty. And the cruelty, you may say, the commission offence under section 498A of Indian Penal Code. FIR was registered and thereafter charge sheet was placed before the judicial magistrate. This at Isar. The petitioner, husband, and there may be his relatives also who have been impleaded as accused. They have also approached the Honorable High Court of Punjab and Haryana, but the Punjab and Haryana High Court has declined to quash the FIR, which has culminated into charge sheet. But thereafter, the Achin Gupta petitioner approached the Supreme Court of India, and by way of a SLP, and it may be have converted into this criminal appeal. The Supreme Court of India, in this case, have discussed and referred many judgments where there is a misuse of. There is a reference that this section has been misused. In this Achin Gupta's case, you will find the allegations are against the husband as well as his relative. Moreover, the extramarital relation, demand of dowry, all what you can incorporate in a FIR, in a offence for commission of offence under section 498A. Now in Achin Gupta's case, a very judgment, their lordship have referred many judgments, discussed many judgments, and particularly judgment of Preeti Gupta versus state of Jharkhand have been referred. This you will find, I am directly going to para 35, 36 and onwards. Then now para 36. 35 relates to, there is a reference of Mahmood Ali judge versus others versus state of UP. There is also a principle laid down how, if there is a general type of allegation, the allegation at whole, if it considered true, no offence is made out, then the Honorable High Court can invoke its jurisdiction under section 482 of Code of Criminal Procedure for questioning the FIR. This has been discussed. Now, I am not going into detail. I am directly go to section this 36 para, where in this judgment of earlier judgment of Preeti Gupta have been discussed. Now I will read out. Foregoing reason, we have reached to the conclusion that even if criminal proceedings are allowed to continue against the appellant, this is observation of Honorable Supreme Court of India, the same will be nothing short of abuse of process of law and travesty of justice. This is a finding, conclusion drawn by the Lordship in this case. This is a fit case wherein High Court should have exercised its inherent power under section 482 of Code of Criminal Procedure for the purpose of quashing of the criminal proceedings. I mean, the observation, there is a finding drawn by their Lordship that High Court would have quashed the FIR by invoking its jurisdiction under section 482 of Code of Criminal Procedure. Now, para 37, which is very relevant to the present matter. Before we close the matter, we would like to invite the intention of legislature to the observations made by this court almost 14 years ago in Preeti Gupta, as referred in para 26 of this bill. We once again reproduce para 34 and 35 respectively. This is in these two paras. A direction was made to this Government of India to look into these provisions. I will read out. You will find before parting. This is an observation in Preeti Gupta's case. They have reproduced. Their Lordship have reproduced para 34 and 35 of Preeti Gupta's judgment, which I am now going to read. Para 34. Before parting with this case, we would like to observe that a serious relook of the entire provision is warranted by the legislation. Now, such a demand, cry is among the society that its misuse is being done by the women folk, you may say, her parents and wife at its own. Now, this is observed, and this criminal courts, this law courts have also taken notice of this misuse. And now it is also a matter of common knowledge that a exaggerated version of incidents are referred in a large number of complaints. The tendency of over implication is also reflected in a very large number of cases, but I have said it verbally. This is contained in this para. Now, para 35. The criminal trials led to immense suffering for all the concerned. लंबा होता है trial. It goes long. The one has to face the trial for years together because it's a criminal trial. Even ultimate acquittal in the trial may also not be able to wipe out the deep scars of the sufferings of ignominy. Unfortunately, a large number of these complaints have not only flooded the courts but also have led to enormous social unrest affecting peace, harmony, happiness of a society. Marital dispute, many marital disputes by way of when you implicate somebody in criminal proceeding have get aggravated. It is high time that legislature means. This is a observation finding of their lordship in Preeti Gupta's case. Their lordship have mentioned 14 years back. Height that a legislature must take into consideration pragmatic realities and make suitable changes in the existing law. It is imperative for the legislature to take into consideration the informed public opinion and pragmatic reality in consideration and make necessary changes in the relevant provisions of the law. We direct the registry to send a copy of this judgment to Law Commission and to Union Law Secretary, Government of India, who may place it before the Honorable Minister for Law and Justice to take appropriate steps in the larger interest of state. But nothing has been done. Same provisions, same verbatim provision of 498 you will find in two sections 85 and 86. There was a direction of the Supreme Court of India 14 years ago, but nothing has been done. Equally situated, same type of, you may say, the provisions have been now added, incorporated in new this Bharatiya Nyaya Sanhita 85 and 86. This, you mean the Supreme Court of India again in this case reminded the Government of India, the Ministry of Law and Justice, and by sending a copy to the concerned ministry, it means direction of Supreme Court have been and this have not been considered or otherwise taken into consideration. And even Law Commission, I don't think what happened by the Law Commission and this have not taken and repeated these provisions of 498A Indian Penal Code in Bharatiya Nyaya Sanhita. In aforesaid consent, we looked into section 85 and 86 respectively of Bharatiya Nyaya Sanhita 2023, which is to come into force with effect from 1st July, so as to ascertain by the legislature has seriously looked into suggestion of the court as made in Preeti Gupta, Supra, section 85 and 86. I have already mentioned that similar situated provisions are now having incorporated. Husband or relative of this husband of a woman subjecting her to cruelty. Same definition, heading you will find in 498A and explanation. Now there are two sections, cruelty defined. This is the definition of cruelty you will find in this section 86 of Bharatiya Nyaya Sanhita. Now, para 39 of this judgment of Supreme Court of India. The aforesaid is nothing but verbatim, but I have already mentioned before you that there is no change, verbatim reproduction of 498A of IPC. The only difference is that explanation to 498A of IPC is now by way of separate provision, section 86 of the Bharatiya Nyaya Sanhita. We request, this is again a request is made in continuation of the this direction made to in Preeti Gupta's case. We request the legislature to look into the issue as highlighted above, taking into consideration the pragmatic realities and consider making necessary changes in section 85 and 86 respectively of the Bharatiya Nyaya Sanhita before both the new provision come into force. In the result, the appeal succeeds and is hereby allowed. The impugned judgment and order passed by the High Court is set aside. But you mean, no doubt, in this Achin Gupta's case, the impugned order passed by the Honorable High Court of Punjab and Haryana was whereby the High Court has declined to quash the charge sheet, the criminal proceeding against the husband and his relatives. What this court has set aside, they quashed the charge sheet by over setting aside the impugned order of the High Court. But simultaneously, they have taken serious view. No doubt, serious view. The judgment 14 years ago, a direction was made to the legislature, law commission, to the law minister, have not been taken into consideration. The Honorable Supreme Court of India had retreated the direction in Preeti Gupta and again sent. But unfortunately, this judgment is of 3rd May 2024. This judgment has also not been considered, and on 1st July 2024, in these two provisions, 85 and 86, you will find in without any change in this BNS. It means deaf ears have been given to the directions made earlier 14 years by the legislature, by the law ministry, law and justice ministry, and law commission, you may say. Then this is, but now you have to discuss, you have to make out your viewpoint. By the Supreme Court's direction have not been considered, not taken into consideration, or otherwise acted upon by this legislative parliament, or you may say Ministry of Law, Law Commission. Seriously, this is up to you to comment. And so now I have found this judgment, and I have noticed, come across, and accordingly I have relied upon this. This is sufficient for today. Again, I will be with you with a new episode on new topic in next episode. Thank you. Thank you very much.